Hello, and welcome to Ipsy Dixit, a podcast on legal scholarship. I'm your host, Lu Nguyen, a college student and the co-founder of the Oberlin Policy Research Institute, an undergraduate public policy research organization based at Oberlin College. My guest today is Akshaya Kamalnath, a lecturer in corporate law at the Auckland University of Technology School of Law. We will be discussing her article, Corporate Insolvency Resolution in India, a proposal to overcome the initiation problem, forthcoming in the University of Missouri, Kansas City Law Review. Welcome, Professor Kamalnath.
Thank you.
So first of all, let's go into why did you write this paper, what got you interested in it, and what's the general scope of this paper?
Okay, so why I wrote this paper, I teach corporate insolvency law in Australia, but I'm from India, so I follow corporate law developments in India. And the paper is really about the insolvency and bankruptcy law in India, which was introduced in 2016. So I got to looking at it and I was interested in writing about it right from around 2016, but it was so fluid with so many changes and developments since then that I kind of put that on hold. But earlier this year, I think it was a kind of cross fertilization of ideas from Australia, India, and generally internationally that I got to writing this paper. So the paper is mainly looking at one aspect of the entire insolvency resolution process for companies, and that is really at the pre-insolvency or the just before a company or other parties initiate a resolution process. So while this paper is really about the problem in India, this is kind of an issue in a lot of other countries as well. So I think it would be interesting. And the paper started out as a larger project, but it kind of got out of hand. So this paper only deals with the initiation problem, and there's a part two that I'll be working on later.
So let's go over the basics of the corporate law in India. The old law preceding this new law, the Insolvency and Bankruptcy Code of 2016, and how it plays into the structures of these laws and how it affects business decisions and business law.
Yeah, so the interesting thing about the time before this law, the insolvency and bankruptcy law was introduced in 2016, is that there was really a it was very piecemeal for anyone. So we had a lot of options if a company was going to restructure or become insolvent, depending on who wants to initiate a restructuring process. If it's a creditor or the company or the type of creditor you or the type of company, you had various different options and different forum for each of these parties to go to. So it was very piecemeal and broken down. So let's think about secured creditors, so like banks or other secured creditors. They had a completely different forum called the debt restructuring tribunal if they wanted to enforce their secured debts against a company, um, and that was treated as a contract law issue. They could also just go to civil courts. It's really up to the uh, financial creditor to choose their option. And the company itself, under the Companies Act, could try and use something called a scheme of restructuring, or they could just wind up the company. Now, this scheme of restructuring was quite complicated because it was very process. It had cumbersome processes with the court being involved at every stage, and the courts in India are notorious for delays. So companies didn't really choose that option. And actually, more interesting for my paper is a third option for industrial companies. There was a legislation known as the Sikh Industrial Companies Act. Now, this is interesting because, unlike all the other options, this particular legislation focused on restructuring or reviving the company. So while this looks great, actually the focus, if you look at the history of the law, was more on a kind of socialist kind of ideology of ensuring people don't lose their jobs in large companies. So while courts really want to revive or restructure companies, rather than assessing if the company is viable enough to revive, they're kind of focused on saving jobs. So since they're always tending towards reviving the company, we tended to have a lot of problematic decisions in terms of viability. So that law was also problematic because it went into even when so basically the court, the tribunal that decided on a viability was the known as the BIFR, and that could then be appealed to the high courts. So at various levels, when it went into appeals, the courts tended to again re examine issues despite the previous court already assessing viability. So, what I'm trying to get at is there were huge delays under that law. So, for a company to just to assess viability, it would take about 3 or 4 years. And even after you assess viability, very few companies actually revived. Many companies were liquidated after it was assessed by these courts that they're actually viable enough to revive. So, basically what happened, the fallout from that law was that it became really infamous or notorious in a way for all these delays, and this model of leaving the company, that the corporate debtor management to continue to be in control, known as the debtor in possession model followed in the US. So that model itself got blamed for all the problems with Sika, whereas really the problems happened with the assessment in the courts, etc. So I think that really influenced the model chosen by the new law, the Insolvency and Bankruptcy Court, which decided not to go with the debtor in possession model followed in the US. Um, Rather, it follows the model followed in the UK, where the moment a company enters into corporate resolution process, the management loses control and control passes to an insolvency professional. So I think the Sika had this kind of, that is the Sikh Industrial Companies Act that I'm talking about, had this kind of impact on the new law, and I go on to criticize that the fallout from that later on in the paper.
So in Indian law, well, in the Indian system, there is something that's pretty basically foreign to most observers, which is what a promoter is. Can you go and talk about what promoters are and how they uh, influence these laws and the impacts that they have on uh, business law in India?
Right. So I think in most, the term promoter itself is not foreign to corporate law in most countries, because by promoter in most countries, we understand that term to mean people who, prior to the company being registered, they go around promoting the company. So they're known as promoters at that stage. And once the company is registered, then they just become, if they're signed on as directors or shareholders, they have or people with key managerial roles, you refer to them by those terms. But in India, where most of the companies, the large companies, are owned by family groups, we tend to continue referring to management as promoters. So when we say promoters, we really mean management and directors of the company, because essentially those people who went and promoted the company, members of the family group, continue to remain in control, and they probably hold key managerial roles, director roles, um, and are also controlling shareholders in the company. So the point really is, it's not just a term that we use to refer to them. The impact of this kind of uh, situation where promoters are in control actually can be seen in the Sikh Industrial Companies Act that I discussed earlier. So there lets the debtor remain in possession of the company, that is the debtor company management, which is in India the promoters. So when they remain in possession, and they're really, we don't see much difference between uh, the majority shareholders and the controllers. So they're just promoters. So it gives them a chance to kind of conceal any issues, any problems in running of the business, etc. So I think that's another reason the new insolvency and bankruptcy code wanted to shift the control from management or promoters to the insolvency professional, just because there's already so much lack of transparency. So yes, that has a huge impact. And uh, maybe that kind of is the reason the debtor in possession model was kind of not really embraced in India. And the time that we did embrace it under the Sikh Industrial Companies Act, it didn't work so well. But as I say later, there are ways to overcome this. Even if you have a debtor in possession model, you can still have an external person, the same insolvency professional, maybe just put him or her in as special director or special independent director to be part of the management processes, so to provide transparency. But yeah, we don't, that's kind of this issue of promoters has really I think influenced a lot of the way the IBC, the new law, was structured.
So, particularly, let's dive in a little more on how the IBC is structured and how uh, bankrupt and insolvent corporations would be treated and how debtors and creditors act under this system of law.
So, under the new insolvency and bankruptcy code, basically, after kind of deciding not to use the debtor in possession model, mainly because of the failures of the Sikh Industrial Companies Act, what the legislation does is basically allow for creditors of the company or the company itself to take the company into this process known as the corporate insolvency resolution process. Now, previously, I mentioned the courts were a big problem under the Sikh Industrial Companies Act. You had a tribunal called the BIFR, and then you had appeals going to the courts. And I guess I didn't mention there that another problem was that those tribunals and courts didn't really have the expertise, the business expertise, to decide upon viability. So all of this was kind of has been addressed in the new law. So there are a lot of great things that the new law addresses. First of all, it creates a company law tribunal known as the NCLT, the National Company Law Tribunal. So there are company law tribunals across the country, and then there's an appellate company law tribunal where appeals from these tribunals can go. Now, all these tribunals are staffed with former judges, but also what are known as technical members, so members with business expertise. So that's something good that the new law has done. Now, this tribunal basically has a big role to play. When either the company or creditors decide to initiate the corporate insolvency resolution process, they basically approach the company law tribunal known as the NCLT, and the NCLT then quickly makes decisions as to whether to enter the company into the insolvency resolution process or not. The other thing was, because under the previous system you had a lot of delays, the new law actually sets very clear timelines that even for small processes, like how long can a company law tribunal take to decide whether or not the insolvency process can be initiated. That's 14 days. So there's all these strict timelines mentioned at various stages, which is a good thing. Um, the other thing it does, and I think this is kind of unique to India. If you compare with bankruptcy systems in other countries, it kind of divides up the type of creditors. So it calls one category as financial creditors, which would be the banks and the large financial creditors, and the other category would be operational creditors, which includes trade creditors and also employees. So that's actually pretty interesting, to give employees a right to actually take the company to the insolvency resolution process. So the new law actually sets up all of these processes quite well. The problem really is that the company itself, the corporate debtor, the company management or promoters don't have enough of an incentive to actually initiate this corporate insolvency resolution process, because under the new law, the terms under which the insolvency resolution process can be initiated is if there is a default of a debt of a minimum amount comes to about 2000 US dollars. So if there's a default, then a financial creditor can directly take the company to the insolvency resolution process. It then just says that the corporate debtor can also start the insolvency process if there's a default. So there isn't really much of an incentive beyond the company wanting to restructure with the help of an insolvency professional. And with employees or trade creditors, they can then take the company to the NCLT to start the insolvency resolution process. And we've had a few cases where employees and trade creditors have taken companies to start the process. But I think more or less, yeah, it's an even split between financial creditors and operational creditors who've taken the company to start the process. But I think the difference really is, the problem really lies with large companies, because what I discussed about promoter groups being in control of companies, this happens a lot with large companies. So it's really with these companies that I talk about the initiation problem, where nobody is initiating the insolvency process under the law.
So why does the insolvency problem happen?
The initiation problem, yeah, in these big companies. So imagine a company is insolvent for a number of months or even years, and the corporate debtor, that is the promoters, don't want to enter the company into the insolvency resolution process, because they don't want to lose control of the company, because control then passes to an insolvency professional. So ideally, the law, the way it's structured, basically expects the creditors to take the company to the insolvency resolution process. But what we're seeing is, in a lot of these big companies, that's not happening. And that's really curious, because after this law was introduced, the Federal Bank of India, the Reserve Bank of India, which is the federal bank, actually issued a circular asking all the big banks to clear up their balance sheets, because they'd accumulated a lot of what is known as non-performing assets from these big companies. Basically, they hadn't paid; they defaulted on a number of loans. So it's really curious that these banks are not taking the company to court, but even though you have this new law in place, and you had the federal bank actually asking these banks to go ahead and do this. And the answer really lies in, again, understanding the bank structure in India. A lot of these banks in India are state owned banks, so they're not really under the same pressures of the private banks. And they really want to have their uh, to keep status quo and hope that the companies would pay one day. Because if you take the company to the insolvency process, and if the company gets liquidated, then they probably take huge cuts on what they're owned, so they'd rather just stay in status quo. Also, these large promoter groups are very influential families, since they've been controlling the capital of the big companies for a number of years. They're very well connected, so you can well imagine how the creditors and promoter groups are actually in kind of helping each other by not initiating the insolvency process. And the other thing is, when the law actually allows employees and operational creditors to go ahead and initiate the process, why hasn't that happened with these big companies? So when I try to explore that, there's no clear answer to that, except that maybe these employee unions are in negotiations with promoters and kind of hoping it would be settled out of court because of our India's history of the insolvency resolution not being very good. So maybe there isn't that kind of faith in the insolvency law, insolvency law anymore. So at least in these big companies. Um, so I think I use the example of Jet Airways, this case that was really big in the media, and I think it's still almost every day there's a new development with this case, which nicely sets out the initiation problem. So maybe I can talk about that, the case itself.
So yeah, let's go on about the background of Jet Airways because you use it as an example in
Hmm.
your paper about the initiation problem. This airline that had some significant financial problems, but no one put them through the process prescribed by the law.
Yeah. So the initiation problem that I was talking about, where nobody actually initiates the insolvency law that is really structured and developed for this process, and it's not being used. And I use this Jet Airways case because just because it's so big, there's a lot of news items about it because it's really hard to figure out why nobody is initiating the insolvency process because all these things are happening behind closed doors in negotiation processes. So with Jet Airways, basically there was news reports of it was clear to everyone that Jet Airways had huge financial problems. They were, in fact, looking for bidders, any interested parties to invest. And they actually had two very interested bidders. I think Tata and Etihad Airways. And not every news article covers this, but one or two news articles talk about how the condition for these companies, both Etihad and Tata, to invest in Jet Airways was that the chairman of the company Jet Airways, Naresh Goyal, who is a member of the promoter group, so we just refer to him as the promoter of the company. So they wanted the promoter to step down from the chairmanship in order to invest, as a condition to invest. And the promoters were not happy with this condition, so they didn't accept these bids. So on the one hand, you have these neither the employees nor the banks have initiated the insolvency code. On the other hand, you have some interested bidders who may help out the company, but those bids are being rejected by the promoters. And you're seeing in the news every day where employees are talking about how they haven't been paid for a number of months, and you really have to wonder why these employees didn't just initiate the insolvency code so that the insolvency process is triggered and the company can be restructured. So, in one of the interviews, the biggest creditor of Jet Airways, the State Bank of India, which is another state owned bank, basically says that the moment they initiate the insolvency process, then there is really no hope of restructuring because it's a service industry. Jet Airways is an airline company, so maybe they'll go out of business as soon as they start the insolvency process. So it just shows that there isn't much faith in the insolvency process on the creditor's part for to as one part of the explanation. But another part of the explanation is this very connected promoter who seems to want to retain control and is rejecting bids. So ultimately, till today, they haven't really. Actually, after this paper was written, I think more a week or 2 weeks back, ultimately you have trade creditors that have gone to the company law tribunal to initiate the insolvency process, and there's still no determination on that. But it's taken all this while, and by now I think there is really no hope because there are no bidders anymore. So that's really a the Jet Airways case, I think, nicely brings out the initiation problem that I talk about in this paper.
So, in your paper, you go over potential solutions for the initiation problem, bringing in examples from Australia and the United States. Can you expand on that?
Yeah, so the actually Australian corporate insolvency is going through its own reform process at the moment. So I had that in mind. And when I'm looking at the Indian process where there is really lack of incentive for promoters to file for insolvency. What really struck me is the stark contrast with Australia, where the problem really that the new reforms were trying to solve was the other extreme, where directors of companies are filing for the insolvency process, which is known as voluntary administration in Australia. They're starting the process very early, so it was a problem of directors not trying to restructure out of court and going to the formal process prematurely. So more of a risk averse situation where even companies that may have been restructured is being put into this voluntary administration process and might just be liquidated because of premature entry into the process. So why this disparity, and what are the incentives at play here is what I something I examine, and I see if we can possibly pick something up from Australia to begin with. Uh, but really, the Australian law, the reason this kind of directors are set up to file for premature insolvency in this manner in Australia is because Australia has a law known as personal liability for directors for insolvent trading. Now, this law is very, very strict. Basically, it says that if directors know or have reason to believe that the company is insolvent or will become insolvent when they enter into a certain debt, then they would be personally liable for any debts entered into. So this fear of personal liability basically makes directors enter the company into insolvency in the nearest, even when they see a threat of insolvency. So the law reform in Australia tried to actually overcome this problem by coming up with something known as the safe harbor. So the safe harbor tries to say that this liability for insolvent trading will not apply if directors are doing certain things. And what are these certain things? It says directors should be trying to find a course of action or a plan for the company that will result in a better outcome than just entering the company into the formal insolvency process at the time. So it is pretty vague, and this new reform is, I mean, law reform is new, so we haven't seen any cases of what these courses of action or plan of action are meant to be. But one of the, if you look at the legislative guidance, one of the things it says is if they're getting advice from a restructuring professional, so then they have this safe harbor protection. So this looks like an interesting thing you can use in India, but the problem really is if you think about using something like this in the Jet Airways case. If Jet Airways was operating under the Australian insolvency law with the safe harbor, what would happen is you can think of promoters really just getting an insolvency or restructuring expert on their roles and paying them and saying that yes, we're negotiating, we're trying to devise a plan, and they go on rejecting bids that require them to give up control of the company. So there's no real way to say that what they're doing is really harming the company. So basically, I reject the Australian model after looking at how it might work in the Indian context. And then I look at not really the US bankruptcy law, but a very different law coming out of the case, the Delaware case, Revlon, which basically says that when a company is when a company has effectively been put on sale and the company is actively seeking bids, then the directors are not really looking at looking at anything else, but they have a duty to just maximize returns for shareholders and accepting the highest bid. And of course, there's a lot of criticism of the Revlon case itself in the US, but the context is different in India, and I'm trying to apply it to the insolvency context, rather the pre-insolvency context, where promoters, like in a case like Jet Airways, promoters really want to get capital, but they want to retain control. But if you think of what's good for the company, maybe a change of control is the right thing here, because the companies, if you have a the choice between accepting a bid from someone who requests a change of control versus just liquidating the company, then you would, for the sake of all the stakeholders in the company, choose the first choice, right? So the Revlon duty, or a modified Revlon duty, as I call it in the paper, would actually be a very good idea in this context, where in the Jet Airways context, for example, if you have a Revlon duty in the pre insolvency stage, saying that now that the promoters have been actively seeking bids, then they are forced to sell to the highest bidder. If that rule existed, they would have had to sell to Etihad or Tata, and the company would still be functional at this point. So that's what I try to put into my proposal to make the insolvency law more efficient.
So, can you think of any other examples on how this would play out uh, in other examples besides the Jet Airways case? How a mandatory requirement to take the highest bid if you're seeking bids would change the structure of uh, the way that the insolvency and bankruptcy code is uh, applied by current companies that are on the verge of insolvency and bankruptcy?
Actually, it's kind of hard to pinpoint examples of cases that have these sort of, where you have this kind of detail that I have about Jet Airways, simply because Jet Airways was such a high profile case. So we have in the news information about what bids they had, why they rejected bids. So we really don't have so much information in many cases. But what I basically propose would kind of would kind of make this pre-insolvency stage a useful stage in itself, and kind of work as what actually someone else calls as a de facto Chapter 11 uh, in context of other countries. So while I don't have those sort of specific examples, in India, there's apparently a lot of cases that enter into the successful cases that have entered into settlements prior to the company being taken into the insolvency process. What this shows is that the creditors and promoters both don't really want to go into the formal insolvency process unless they really have to. And the finance minister in India actually has some sound bites about how they do recognize that a lot of companies have been settled before entering into the insolvency process, and it's a good thing. So if there is a way to kind of recognize that and encourage that, that is something the government would be looking into as well, is what I see from news reports. So basically, along with proposing that we need to have this sort of modified Revlon duty, I also go into a little more detail about where to put this proposal in. So I start off, when I discussed the Sikh Industrial Companies Act earlier, I started off saying that we really needed the debtor in possession model to in India so that it would work more efficiently. But since the insolvency law in India hasn't taken that route, that kind of suggestion is moot right now. So what I do is I try to make a suggestion that's easily workable under the current regime. So, without really changing the current insolvency law, what I say is we can tweak the director's duties provisions in the company law. And the director's duties provision in India's company law is actually very interesting, because most director's duties provisions in other countries just talks about directors having duty to look into the best interests of the company, whereas in India's latest iteration of the company law, basically we have this section that tries to do something like the UK's enlightened shareholder value model. So the section kind talks about how directors have a duty to consider the best interests of the company, and then it adds language about other stakeholders. So it says shareholders, employees, environment. But it's kind of interesting that there's no mention of creditors. While if you look at the common law cases, in most common law jurisdictions, we say that when a company starts to get closer to insolvency, in the zone of insolvency, then directors have to consider the interests of the creditors as well. So, what I propose is to kind of introduce within that directors' duties provision in our company's law uh, language about creditors as well, especially in the pre insolvency stage. So that kind of gives an opening when you're talking about pre insolvency stage, interests of creditors. It gives an opening to the legislature to also talk about how directors would consider interests of creditors in that pre insolvency stage. So that's where I say that we could put in language to say that if if they engage in restructuring process, then they should, when they put the company on sale or when they're looking for bids, then they should accept the highest bid, or they should just enter the company into the formal insolvency process. So this kind of sets up incentives for everybody nicely, because when you have this sort of rule, promoters who want to retain control might think that if they don't want to sell to the highest bidder because they're asking them to give up control, it may be better to actually enter into the formal insolvency process. And since the formal insolvency process again allows for opportunities to accept bids, it's not such a bad outcome. And for creditors as well, they would kind of be more involved in the process pre insolvency as well, because they know that they have some sort of more weightage in terms of bargaining power, in terms of talking to promoters prior to in the pre insolvency stage. And the real advantage of putting in this language in the director's duties provision is that shareholders have an incentive to actually enforce this provision, because at this point the company still has a chance of being solvent. So shareholders would try and enforce this provision if they think that accepting that bid is going to revive the company and then the company stays solvent. On the other hand, if the company is anyway going to become insolvent, go into the insolvency process, shareholders don't have much incentive to get into the issue because they're the residual claimants anyway. So I think putting this into the directors' duties provision sets up incentives for a lot of stakeholders pretty well.
So in the beginning, you said that this article was part of a larger project that you've now split into two articles. So this is your first major part of it. What's the second part that you plan to publish in another paper in the future?
Right. So when I started off this article, it was meant to be a general discussion of the problems in the insolvency law at various stages. So the first stage was going to be the initiation stage. Second stage was going to be after the insolvency professional is appointed. What were the problems? Because those cases wherein the company does enter into the insolvency resolution process, there's a lot of adversarial relationship between the company, the insolvency professional, and the creditors. In fact, there are very shocking instances of an insolvency professional being locked in overnight in a data room in a company, or in some cases where the insolvency professional is not denied access at all into the premises. So I thought there's a very interesting problem to look into, but the initiation problem itself was, I thought, quite interesting to deal with separately. So I decided to deal with the second stage later in a subsequent paper.
So in for concluding remarks, what would you like for policymakers, for judges, and for regulatory institutions in India and beyond India to take from this paper?
So, the initiation problem, like I said, I'm talking about Indian insolvency law, but the initiation problem is kind of relevant in a number of countries which don't have the Chapter 11 system of the corporate debtor remaining in possession. So, I think policymakers in India have been very open to taking suggestions from business, academia, etc., and making changes in this law. So I think this is a workable proposal that I would like them to take into account and put it kind of uh, tighten the pre-insolvency system in India, and I think it could be relevant to a number of other countries following similar UK style models as well.
Right. Well, thank you very much, Professor Kamalnath, for coming on the podcast to talk about your very interesting new article.
Thank you, Luz. I enjoyed this.
Guarantee of Bank Deposits by William Jennings Bryan, Edison Record. Remedies appear as fast as evils are recognized, for laws are the outgrowth of conditions. A few have for many years been advocating greater protection to bank deposits, but bank failures are not frequent, and the number of those who lose is so small in comparison with the total number of depositors that until recently there was no widespread response to the suggestion. In the fall of 1907, however, when banks all over the country suspended payment on checks, the people at once realized the evils of insecurity, and there is a growing sentiment in favor of legislation which will guarantee depositors by requiring all banks to stand back of each bank. The government requires security for its deposits. Why should not the individual depositor be protected? In Oklahoma, a guarantee system is already in operation, and the experience under it has been very satisfactory. There, the banks contribute in proportion to their deposits to a guarantee fund, and the banking board has the power to assess all the banks to keep this fund up to its maximum. The result is that deposits are rapidly increasing in the secured banks of Oklahoma and decreasing in the unsecured banks. This system not only relieves the depositor from anxiety, but it protects the community from the business embarrassment that follows a bank failure, while the banks are more than repaid for the small tax upon them by the increased deposits that are brought from hoarding and hiding. It is only a question of time when the Oklahoma system, or some similar one, will be adopted in the nation and in all the states. But in order to avoid discrimination, the national system should permit state banks to take advantage of it in states which have not established a guarantee system, and state systems should extend the advantage to national banks until a national system is established.